Marginal note, qualifications of a senator. 23. The qualifications of a senator shall be as follows. 1. He shall be of the full age of 30 years. 2. He shall be either a natural-born subject of the Queen, or a subject of the Queen naturalized by an Act of the Parliament of Great Britain, or of the Parliament of the United Kingdom of Great Britain and Ireland, or of the legislature of one of the provinces of Upper Canada, Lower Canada, Canada, Nova Scotia, or New Brunswick, before the Union, or of the Parliament of Canada, after the Union. 3. He shall be legally or equitably seized as of freehold, for his own use and benefit of lands or tenements held in free and common soccage, or seized or possessed for his own use and benefit of lands or tenements held in franc lieu, or in rotor, within the province for which he is appointed, of the value of $4,000, over and above all rents, dues, debts, charges, mortgages, and encumbrances due or payable out of or charged on, or affecting the same. 4. His real and personal property shall be together worth $4,000 over and above his debts and liabilities. 5. He shall be resident in the province for which he is appointed. 6. In the case of Quebec, he shall have his real property qualification in the electoral division for which he is appointed, or shall be resident in that division. And note 13. Marginal note, summons of a senator. 24. The Governor-General shall from time to time, in the Queen's name, by instrument, under the Great Seal of Canada, summon qualified persons to the Senate, and, subject to the provisions of this Act, every person so summoned shall become, and be a member of the Senate, and a senator. 25. Repealed. And note 14. Marginal note, addition of senators in certain cases. 26. If at any time on the recommendation of the Governor-General the Queen thinks fit to direct that 4 or 8 members be added to the Senate, the Governor-General may by summons to 4 or 8 qualified persons, as the case may be, representing equally the 4 divisions of Canada, add to the Senate accordingly. And note 15. Marginal note, reduction of Senate to normal number. 27. In case of such addition being at any time made, the Governor-General shall not summon any person to the Senate, except on a further like direction by the Queen, on the like recommendation, to represent one of the 4 divisions, until such division is represented by 24 senators, and no more. And note 16. Marginal note, maximum number of senators. 28. The number of senators shall not at any time exceed 113. And note 17. Marginal note, tenure of place in Senate. 29. 1. Subject to subsection 2. A senator shall, subject to the provisions of this Act, hold his place in the Senate for life. Marginal note, retirement upon attaining age of 75 years. 2. A senator who is summoned to the Senate after the coming into force of this subsection shall, subject to this Act, hold his place in the Senate until he attains the age of 75 years. And note 18. Marginal note, resignation of place in Senate. 30. A senator may by writing under his hand addressed to the Governor-General resign his place in the Senate, and thereupon the same shall be vacant. Marginal note, disqualification of senators. 31. The place of a senator shall become vacant in any of the following cases. 1. If for 2 consecutive sessions of the Parliament he fails to give his attendance in the Senate. 2. If he takes an oath or makes a declaration or acknowledgement of allegiance, obedience, or adherence to a foreign power, or does an act whereby he becomes a subject or citizen, or entitled to the rights or privileges of a subject or citizen of a foreign power. 3. If he is adjudged bankrupt or insolvent, or applies for the benefit of any law relating to insolvent debtors, or becomes a public defaulter. 4. If he is attainted of treason, or convicted of felony, or of any infamous crime. 5. If he ceases to be qualified in respect of property, or of residence, provided that a senator shall not be deemed to have ceased to be qualified in respect of residence by reason only of his residing at the seat of the Government of Canada, while holding an office under that government requiring his presence there. Marginal note, summons on vacancy in Senate. 32. When a vacancy happens in the Senate by resignation, death, or otherwise, the Governor-General shall by summons to a fit and qualified person fill the vacancy. Marginal note, questions as to qualifications and vacancies in Senate. 33. If any question arises respecting the qualification of a senator, or a vacancy in the Senate, the same shall be heard and determined by the Senate. Marginal note: Appointment of Speaker of Senate. 34. The Governor-General may from time to time, by instrument, under the Great Seal of Canada, appoint a senator to be Speaker of the Senate, and may remove him, and appoint another in his stead. End note. 19. Marginal note: Quorum of Senate. 35. Until the Parliament of Canada otherwise provides, the presence of at least 15 senators, including the Speaker, shall be necessary to constitute a meeting of the Senate for the exercise of its powers. Marginal note: Voting in Senate. 36. Questions arising in the Senate shall be decided by a majority of voices, and the Speaker shall in all cases have a vote, and when the voices are equal the decision shall be deemed to be in the negative. The House of Commons. Marginal note: Constitution of House of Commons in Canada. 37. The House of Commons shall, subject to the provisions of this Act, consist of 308 members, of whom 106 shall be elected for Ontario, 75 for Quebec, 11 for Nova Scotia, 10 for New Brunswick, 14 for Manitoba, 36 for British Columbia, 4 for Prince Edward Island, 28 for Alberta, 14 for Saskatchewan, 7 for Newfoundland, 1 for the Yukon Territory, 2 for the Northwest Territories, and 1 for Nunavut. End note. 20. Marginal note: Summoning of House of Commons. 38. The Governor-General shall from time to time, in the Queen's name, by instrument, under the Great Seal of Canada, summon and call together the House of Commons. Marginal note: Senators not to sit in House of Commons. 39. A senator shall not be capable of being elected, or of sitting or voting as a member of the House of Commons. Marginal note: Electoral districts of the 4 provinces. 40. Until the Parliament of Canada otherwise provides, Ontario, Quebec, Nova Scotia, and New Brunswick shall, for the purposes of the election of members to serve in the House of Commons, be divided into electoral districts, as follows. 1. Ontario. Ontario shall be divided into the counties, ridings of counties, cities, parts of cities, and towns enumerated in the first schedule to this Act, each whereof shall be an electoral district, each such district, as numbered in that schedule, being entitled to return 1 member. 2. Quebec. Quebec shall be divided into 65 electoral districts, composed of the 65 electoral divisions into which Lower Canada is at the passing of this Act divided under Chapter 2. Of the Consolidated Statutes of Canada, Chapter 75 of the Consolidated Statutes for Lower Canada, and the Act of the Province of Canada of the 23rd year of the Queen, Chapter 1, or any other act amending the same in force at the Union. So that each such electoral division shall be for the purposes of this Act an electoral district entitled to return 1 member. 3. Nova Scotia. Each of the 18 counties of Nova Scotia shall be an electoral district. The county of Halifax shall be entitled to return 2 members, and each of the other counties 1 member. 4. New Brunswick. Each of the 14 counties into which New Brunswick is divided, including the city and county of St. John, shall be an electoral district. The city of St. John shall also be a separate electoral district. Each of those 15 electoral districts shall be entitled to return 1 member. End note. 21. Marginal note: Continuance of existing election laws until Parliament of Canada otherwise provides. 41. Until the Parliament of Canada otherwise provides, all laws in force in the several provinces at the Union relative to the following matters, or any of them, namely, the qualifications and disqualifications of persons to be elected, or to sit or vote as members of the House of Assembly or Legislative Assembly in the several provinces, the voters at elections of such members, the oaths to be taken by voters, the returning officers, their powers and duties, the proceedings at elections, the periods during which elections may be continued, the trial of controverted elections, and proceedings incident thereto, the vacating of seats of members, and the execution of nurits in case of seats vacated otherwise than by dissolution, shall respectively apply to elections of members to serve in the House of Commons for the same several provinces, provided that, until the Parliament of Canada otherwise provides, at any election for a member of the House of Commons for the district of Algoma, in addition to persons qualified by the law of the Province of Canada to vote, every male British subject, aged 21 years or upwards, being a householder, shall have a vote, Endnote 22.